let's take a look at OSHA. The Occupational Safety and Health Act is a federal law requiring private sector employers to keep their workplaces free from hazards that threaten employee safety and health. With it came three new agencies: the Occupational Safety and Health Administration, the Occupational Safety and Health Review Commission, and the National Institute of Occupational Safety and Health. OSHA has an overall responsibility for administering and enforcing the Act. OSHA establishes safety standards, conducts inspections, and provides information to employers and employees about workplace safety and health issues. The Occupational Safety and Health Review Commission is independent from OSHA and hears appeals of its enforcement action. The National Institute for Occupational Safety and Health provides scientific and technical support to OSHA, helping it to identify hazards and to develop appropriate standards. When requested, the National Institute of Occupational Safety and Health visits workplaces and conducts health hazard evaluation. OSHA protects most private sector employees, but not government employees, at least not directly. The Act allows states that prefer to issue and enforce their own safety and health standards to do so, as long as the state programs are certified by OSHA as being at least as effective as the federal program. Another condition for OSHA certification of state plans is that state and local government employees are also covered. About half the states are state plan states. When the Occupational Safety and Health Act runs up against other federal laws affecting the safety and health of private sector employees, laws regarding transportation or nuclear plants as an example, OSHA is generally prohibited from exercising its jurisdiction. The Occupational Safety and Health Act is aimed at eliminating or at least lessening safety and health hazards in the workplace. Unsafe conditions violate the law even if they have not resulted in injury, illness, or death. The latter might prompt enforcement activities or affect penalties, but unsafe conditions by themselves violate the OSHA Act. At its own initiative or at the request of other parties, OSHA has the authority to create safety standards. Separate standards exist for general industry, maritime, construction, and agriculture. General industry standards apply to all industries unless more specific maritime, construction, or agricultural standards deal with the same issues. Employers must become aware of and comply with all standards that apply to their operations. Employers might argue that compliance with the standard would be impossible and that they took other steps to protect workers. Employees do not actually have to be exposed to the hazard that violated a standard nor suffer any harm. It is enough that the nature of their work and the facility make it reasonable to expect that they might encounter a danger. To establish a violation, OSHA must first point to the particular standard that applies. Knowledge of a hazard that violates an OSHA standard can be either actual or constructive. Employers are not expected to be omniscient. They cannot evade their responsibilities by ignoring obvious problems or by failing to exercise reasonable diligence. If a hazard is in plain view, is known to supervisors, or is the object of employee complaints, the employer will be deemed to have known of its existence. Because employers are expected to be aware of applicable standards, professing ignorance that particular conditions violate OSHA standards does not absolve them from liability. Employees sometimes engage in careless and unsafe behaviors that lead to accidents. Under OSHA, an employer can argue that a safety violation occurred because of unpreventable employee misconduct. However, the employer must be able to show that it established rules designed to address the hazard. The rules were communicated to employees, and people violating the rules were disciplined. This defense is also more likely to work where isolated incidents of misconduct by an individual are involved rather than a more widespread or continuous violation. It is impossible for OSHA to develop standards addressing all hazards to which employees might be exposed. It's OSHA's general duty clause that places basic responsibility for workplace safety with employers and can be involved for enforcement purposes in the absence of specific standards. Each employer shall furnish to each employee a place of employment free from recognized hazards that are causing or are likely to cause death or serious physical harm. One of the key requirements for a violation of the General Duties Clause is that workers were exposed to a recognized hazard. Hazards are recognized when there is a reason to believe that they are known to the employer or to the industry in which the employer operates. Recognition refers in this context to awareness that a condition is hazardous to employees, in contrast to the knowledge element in standards violations cases where it's simply awareness of the condition that is the issue. The General Duty Clause provides OSHA with an important and more responsive weapon for contesting unsafe conditions. But it can be difficult for an agency to prove that hazards that have not been the subject of safety standards are recognized and that there are feasible means for abating these hazards. Unlike most other employment laws, OSHA is enforced reactively and proactively. OSHA not only responds to employee complaints of violations, but it also goes to workplaces on its own initiative and conducts investigations to determine whether employers are complying with the law. At the same time, enforcement is not effective without active involvement of employees bringing hazards to OSHA's attention, participating in the inspection process, and occasionally taking enforcement into their own hands. In order of priority, OSHA inspects workplaces where it has reason to believe that there is imminent danger of death or serious physical harm to employees, where it's received employee complaints, and for follow-up inspection. Most OSHA inspections are unannounced. When OSHA inspectors, known as compliance officers, arrive at workplaces, they first locate and present their credentials to the owners or other people in charge. OSHA empowers inspectors to enter workplaces without delay and at reasonable times to examine records, inspect conditions, and question individuals. However, the Supreme Court has determined that the Fourth Amendment rights of employers to be free from unreasonable search and seizure permit them to refuse entry to OSHA inspectors without a search warrant. The right of refusal does not apply if a clear emergency exists, the hazard in question is in plain view, or an authorized party consents to entry even though a co-owner might disagree. Refusing entry is at best a delay tactic. OSHA can generally obtain a warrant from a court by establishing probable cause of a violation or by showing that selection for a programmed inspection was based on reasonable administrative criteria. An employer representative is entitled to accompany the compliance officer during a workplace investigation or inspection, but employers are prohibited from intimidating or interfering with compliance officers as they perform their job. While touring workplaces, compliance officers might write down observations, take photographs, take instrument readings, and ask questions of employees. Apparent violations are pointed out. Although some violations can be corrected on the spot, this does not necessarily preclude issuance of citations for those violations. At a closing conference, the compliance officer goes over the observed violations and the OSHA appeals process. Citations or fines are not levied by inspectors. Instead, the directors of OSHA area offices issue citations and penalties after reviewing inspection reports. Citations for safety violations indicate the nature of the violation, the OSHA standard violated, the monetary penalties associated with the violation, and the amount of time that the employer has to correct the problem. Fines vary according to how severe the violations are and whether they're deemed willful or intentional. Copies of citations received must be posted near where the violations occurred for 3 working days or until the violation is corrected. Employers have 15 days following the receipt of a citation to contest the citation. Although all violations should be corrected promptly, employers are not legally required to correct alleged violations until their appeals have been heard by the Commission and it has issued a final order. The ability to put off fixing dangerous conditions until the Commission's appeals process is completed provides employers with considerable leverage when negotiating with OSHA over citations. Because OSHA visits only a minuscule number of workplaces at its own initiative, employee reports of potential hazards are critical to enforcement. Not surprisingly, some employers take a dim view of such complaints. OSHA does not reveal the identities of employees who make safety complaints, but it does inform employers when inspectors are prompted by complaints and provides copies of written complaints. Employees who refuse to work under dangerous conditions have some legal protection from termination or other punishment for their refusal to work. Employers should take employee safety complaints seriously and must not punish employees for refusing to work under conditions that pose a serious and imminent threat to their health. Employees can request informal reviews in cases where OSHA declines to issue citations, but only the amounts of time that employers are given to fix problems can be formally contested by employees. Employees are responsible under OSHA for following health and safety rules, although employees who fail to do so are not subject to any type of enforcement action. The reason is that employers already have available the means of obtaining employee compliance through discipline, training, and supervision. Keeping records of occupational injuries and illnesses is important to discern patterns that might point to systemic problems and is a requirement of OSHA. Non-exempted employers are required to record all work-related injuries and illnesses that result in death, days away from work, restricted work, transfer to another job, loss of consciousness, or medical treatment beyond first aid. They must also document any other significant injuries or illnesses diagnosed by a licensed healthcare professional. Injuries or illnesses are considered work-related when an event or exposure in the work environment either caused or contributed to the resulting condition or significantly aggravated a pre-existing injury or illness. Employers are required to communicate to their employees specific procedures for reporting workplace injuries and illnesses. These procedures must be designed so as not to deter employees from reporting work-related injuries and illnesses. Reporting procedures that require prompt reporting of injuries but do not allow for situations in which the nature of those injuries is not immediately apparent to employees do not meet the standard of reasonableness. Employers are also required to inform employees that they have the right to report injuries and illnesses without fear of retaliation. Employers are, in fact, prohibited from retaliating against employees who make such reports. Some forms of retaliation are not so obvious. OSHA warns employers that safety incentive programs, disciplinary programs, and drug testing can be administered in ways that constitute retaliation. It is retaliation if an employer requires that every employee injured in a workplace accident submits to drug testing regardless of whether there is any reason to believe that impairment by drugs contributed. Because safety and health conditions can vary considerably between individual workplaces, records must be kept for each separate establishment and not just the entire company. Employers can use OSHA's Form 300, a log of workplace-related injuries or illnesses, and Form 301, Injury and Illness Incident Report, or maintain the same information in other compatible formats. An annual summary of injuries and illnesses must be maintained and posted for employee inspection during the month of February. These records must be retained for at least 5 years and made available for OSHA inspectors. In addition, larger employers and some smaller employers in high injury rate industries are required to electronically submit annual data to OSHA. Records must also be maintained documenting any safety training provided and certifying that certain potentially dangerous equipment has been examined and is in safe working order. If employees are given periodic medical tests to screen for adverse health effects, or if workplace conditions are monitored, like air quality tests, those records must be kept as well. Employers are required to report any fatal accident to OSHA within 8 hours. Any accident that results in the hospitalization of one or more employees, an amputation, or the loss of an eye must be reported to OSHA within 24 hours. Lastly, employers are required, if selected, to participate in the Bureau of Labor Statistics annual survey of occupational injuries and illnesses. This survey is a basic source of data for occupational safety and health statistics. Even firms that are otherwise exempt from OSHA recording requirements have to participate in this survey. Violations of OSHA's record-keeping requirements are apparently common in the workplace. Some OSHA standards specify the particular actions that employers must take, but many other standards leave it to employers to devise a set of controls to lessen or eliminate hazards. OSHA standards reflect the safety principle of a hierarchy of controls. The idea is that measures that remove or lessen hazardous conditions should be fully utilized before relying on means of helping employees stay safe despite unsafe conditions. This hierarchy of controls includes measures that eliminate the hazard, engineering controls that automatically provide protection, and administrative measures that limit the extent of exposure. Trainings and warnings that teach employees how to protect themselves, and personal protective equipment worn by employees as a last line of defense. Employers should focus on designing hazards out of the production process, eliminating existing hazards and reducing them to the maximum extent possible through the use of engineering and administrative control. Training and personal protective equipment are clearly necessary and important, but they do not do anything to make unsafe conditions safer, and they don't address employee behavior. Flexibility and options are desirable in many realms, but not with respect to safety rules. Safety rules should be clear, specific, consistent with one another, and equally enforced. The OSHA Act does not require that all covered employees receive safety and health training. However, many OSHA standards mandate training for employees who are exposed to the particular hazards at which the standards are directed. A failure to train could also violate the general duty clause of OSHA if the hazard is recognized. The hazard is likely to result in death or serious physical harm, and training is a feasible means of abating the hazard. An important OSHA standard that contains substantial information and training requirements is the Hazard Communication Standard. The standard is based on the principle of right to know, the idea that employees have the right to receive information about the dangerous chemicals they encounter on the job so they can take steps to protect themselves. The absence of recordable injuries and illnesses does not necessarily mean that a workplace is safe. OSHA guidelines and contemporary safety practice strongly encourage the implementation of effective workplace safety programs. These programs help instill safety culture in an organization, making safety a central concern that is closely monitored, discussed, rewarded, and continuously improved. Workers' compensation statutes deal with the consequences of workplace injuries and illnesses that occur. Workers' compensation is generally provided for. Workers' compensation statutes require coverage of almost all employees, whether full or part-time, working in either private or public sectors. The major exclusion from coverage is for independent contractors, though firms using employees from contract companies still should ensure that those contractors are providing workers' compensation for their employees. These workers may be at greater risk because they are less familiar with the workplace layout and equipment, and because they are frequently enlisted to perform dirty and dangerous tasks. In almost all states, Texas is the exception and other states are considering opt-out provisions, workers' compensation coverage is mandatory. By law, employers must arrange workers' compensation coverage for their employees. They do so by contributing to state workers' compensation funds, purchasing coverage from private insurers, or self-insuring. The available funding options vary by state. The amounts that must be contributed depend largely on the industry in which the employer operates and, to a lesser extent, on experience rating. Under experience rating, employers that have worse records of injuries and claims pay more, providing a financial incentive to invest in safety. What do injured workers receive? The benefits include replacement of income if an employee is unable to work, payment of all medical costs associated with the injury or illness, and rehabilitation service. Workers' compensation statutes provide only partial income replacement, typically two-thirds of normal pay, on the theory that this will give employees greater incentive to return to work. Employees who work more than one job may be entitled to replacement pay based on their combined income from those multiple jobs, rather than only on the income derived from the job being worked at the time of injury. Payments depend on whether the individual is judged to be temporarily or permanently disabled and whether the disability is full or partial. Survivors can receive payments for employee death. Coverage of medical costs under workers' compensation is separate from any health insurance benefits that the employee receives through an employer. State workers' compensation laws have been the object of much thinking by state legislatures in recent decades. The focus of these efforts has been on cost reduction, and the general result has been diminished benefits for injured workers. Workers' compensation is provided on a no-fault basis, meaning employees receive benefits without having to demonstrate in court that their employers were negligent. Employees need not fend off employer claims that they contributed to the harm they suffered by being careless, that a coworker caused the injury, or that they knowingly assumed risk by accepting their job. These traditional common law defenses to negligence claims, contributory negligence, the fellow servant rule, and the assumption of risk, respectively, do not apply under workers' compensation law. However, the right to receive workers' compensation without proving employer negligence comes at a price. Workers' compensation is the exclusive remedy for accidental injuries and illnesses that arise out of and in the course of employment. Workers' compensation is intended to deal with work-related injuries and illnesses, specifically those that arise out of and in the course of employment. The requirement that the injury or illness occur in the course of employment refers to the time, place, and setting in which it occurs. Arising out of employment refers to the underlying causation of the injury or illness. These phrases seem simple, but they have been the object of much litigation and variability across states in how these phrases are interpreted. Many circumstances raise questions about whether injuries or illnesses arose in the course of employment. Travel by employees outside of commuting to and from work also raises questions about coverage. Injuries that occur while employees are attending to personal activities are generally considered to be in the course of employment and compensable. Brief departures from work activities to attend to personal needs are to be expected. However, employees who are injured while under the influence of drugs or alcohol on the job are usually viewed as having abandoned their jobs and are not entitled to workers' compensation. In cases of injuries caused by coworker misconduct, non-participating employees who are injured by the horseplay or pranks of other employees are generally entitled to workers' compensation. Misbehavior that results in injury but does not constitute a substantial departure from required tasks is likely to be compensable. To be covered by workers' compensation, injuries must not only occur in the course of employment, but they also must arise out of employment. Although these two requirements tend to coincide, this is not always the case. The most restrictive view, the peculiar risk doctrine, finds that injuries or illnesses arise out of employment only if they are much more common to people performing particular types of work. Under the somewhat less restrictive increased risk doctrine, an injury or illness arises out of employment if the employee's work or work environment measurably increased his chances of being harmed over that of the general public. Still broader coverage occurs when courts employ the actual risk doctrine, under which injuries or illnesses are compensable so long as the harm that occurred is a risk of the job, even though the general public might be similarly at risk. The broadest coverage occurs under the positional risk doctrine, where injuries or illnesses are generally covered, provided that the harm would not have occurred unless their job placed them in the position in which they were harmed. Heart attacks and back injuries present problems in terms of deciding whether they arose out of employment. These conditions are common, have many causes, and might simply be aggravated by the demands of employment. Most courts follow the usual exertion rule, under which such injuries are compensable if the normal demands of employees' jobs are such that they might reasonably result in injury. Psychological conditions that follow from physical injuries and psychological stresses that are caused by physical harm are likely to be compensated. Employers should require that employees report all injuries that occur in the workplace as soon as possible. This allows for any needed first aid or other treatment to be provided. Employers should err on the side of caution in referring injured employees for medical treatment. Prompt reporting also puts an employer on notice that a workers' compensation claim might be forthcoming and allows for effective investigation. However, most workers' compensation statutes allow employees substantial time to file claims, and the seriousness of some conditions might not become apparent until a later date. Reports of injury should be investigated immediately and thoroughly. Hazards that caused the injury should be identified and abated. To initiate the process of obtaining workers' compensation benefits, employees go to their employers rather than to a government agency. It is important that employers provide injured employees with information about their right to receive workers' compensation and the forms needed to file for workers' compensation. There is some evidence that this does not always happen, especially for low-wage workers. If a claim is filed, a decision must be made about whether to contest the claim. Workers' compensation claims should not be routinely contested. Reasonable grounds for contesting claims are when the severity of an injury or whether it arose out of or in the course of employment is seriously in question. Employees must not be retaliated against for filing workers' compensation claims. Information about job tasks and requirements should be conveyed to medical care providers so they can make accurate assessments about readiness to return to full-time or light-duty work. Light-duty assignments should be available and considered for injured employees who are not yet capable of fulfilling all of the duties of their former position. Workers' compensation issues often overlap with other laws. The injuries employees suffer on the job often constitute serious health conditions, entitling them to medical leave under the Family and Medical Leave Act. Or they might be disabilities under the Americans with Disabilities Act, in which case the employees would be entitled to leave or other reasonable accommodation, allowing them to perform their regular job. Employers need to be mindful that employees with work-related injuries might be entitled to take leave or receive accommodations to perform the essential functions of their job.